Ladies and gentlemen, welcome to our second webinar on legal basics in Ukraine. This webinar series is loosely based on our publication Marktrecht Steuern, Ukraine Wirtschaft im Aufbruch. The idea behind this is that we inform our members and all interested companies about some very basic stuff with regard to legal and tax issues. And I'm glad to have today as a speaker Alesya Pavlynska, who is the chairwoman of our legal committee and a lawyer with Hogan Lovells in Frankfurt. We're going to talk about corporate structure and corporate governance in Ukraine. We have a second speaker who has a smaller slot. That's my colleague, Adrian Schairer, who is the CEO of our subsidiary, DEinternational. And Adrian is going to talk about what we can do to help you with regard to establishing a structure in Ukraine. And Alesya, I'd like to point out that we are doing this in English because we want to be open to also Ukrainian participants and participants from other countries. But our presenter, Alesya Pavlynska, is based in Frankfurt, and she speaks pretty good German too. So
thank you, Reiner.
Whoever wants to speak to Alesya after this is welcome to do this also in German. Let's get going. The floor is yours, Alesya.
Thank you, Reiner, for the introduction. So I'm Alesya Pavlynska. I'm the head of the legal committee of the German-Ukrainian Chamber of Commerce. And also joining Reiner, just explaining the idea of this series of webinars that we had at our legal committee. We have noticed that now a lot of new investors, well, not a lot, but some new investors are coming to Ukraine in spite of the war, or they are just waiting to enter the Ukrainian market. And we receive a lot of basic questions. And therefore, we at our legal committee decided to organize this series of webinars devoted to different topics of Ukrainian law, but just basic topics. We will just share with you only the highlights and the main issues. So the first webinar was devoted to the topic of Bundesgarantie and guarantees of the federal government of Germany. Today we will speak about corporate law. The next one will be devoted to the employment law, then tax law. So just follow the news of the chamber. You will receive the invitation for these webinars that will take place once a month. So usually at the end of the month, as today. So stay tuned. Now we are starting the main part of today's webinar. Can you see my presentation? It's okay. Yep. So we are going to talk about corporate structures and corporate governance in Ukraine. Often we receive the questions, what are the best forms to establish in Ukraine, to incorporate, what companies are available in Ukraine. And actually the framework is different. So you may see a lot on this slide, several most popular, I would say, legal forms. The limited liability company is the most popular form with foreign investors. There is also an additional liability company, a joint stock company, a representative office of a foreign legal entity, and also what we see, also some other legal forms. We also have partnerships, by the way, limited partnerships, full partnerships. So actually all legal forms that are also familiar to every German investor. Kommanditgesellschaft, but they're not so popular in Ukraine. And this is also not a surprise because a lot of clauses from the German BGB were borrowed by the Ukrainian legislation, civil code, and therefore, if you are new to the Ukrainian market, you won't be surprised that actually a lot of legal forms in Ukraine sound familiar. As for these other legal forms, you see this star here. I will explain this now briefly. So in Ukraine, so I will go back to the history from time to time. After the collapse of the Soviet Union in the 90s, we still did not have the civil code in Ukraine. So the legal forms were not systematized, and therefore some companies, foreign investors who came to the market, they incorporated the companies in the form of, for example, a company with 100% foreign investment, a daughter enterprise, a subsidiary with 100% foreign investment. So these forms are rather weird, but they still exist. And I know that several members of our chamber are still in this form, so exist in this form. It's not illegal, of course. If, for example, you conclude an agreement or deal with any company in such a form, don't be surprised. Well, it's still sometimes common. So this is the sign that the company was established in the 90s, probably. But now with the abolition of the commercial code, all these companies must change their forms. So it's forbidden now to establish this form after August 25. But the existing companies, they must change this form. They have the transitional period of 3 years. But if they don't do this, all the legislative requirements and the provisions of the law on limited liability company will be applicable to them automatically. And if there is any contradiction between the Articles of Association and the law on LLC, so the law on LLCs, so the limited liability company will apply to the articles of such companies. Now going further, here you see a brief overview and the comparison table between the legal entity and a rep office. Because sometimes we receive the questions whether it's worth trying to come to the market in the form of a rep office, whether there are any advantages or disadvantages. So you see the brief comparison on this slide. So as the name suggests, the legal entity is a separate legal entity. It's liable on its own. Well, it can conduct full commercial operations. Of course, depending on the operations, it may need to apply for licenses in Ukraine. Yeah, it must have registered capital, can be financed by the registered capital, by the loans, by the shareholder loans, the bank loans. It is usually well, for example, an LLC can be incorporated within 1 day, 1 or up to 3 days. It's quite a straightforward process. The corporate bodies are usually shareholders meeting, supervisory board, management board, or sole directors. So quite a transparent structure. As for representative office, it's not a separate legal entity. It's part of a foreign company. And of course, the liability rests on the foreign company, the parent company. It often has only limited operations, marketing, auxiliary operations in Ukraine. So usually the rep offices don't conduct full commercial activity. But if they do, then of course they resemble in their nature the legal entity, and they will be taxed as a legal entity in Ukraine. And yeah, we'll also have a separate webinar devoted to the tax issues, so you will receive more information on that. As in terms of financing, the rep offices are financed by the parent company. They established within 5 days, and the director, the head of the rep office, acts based on a power of attorney as a rule. So there is no board, no management board, no supervisory board. So the structure is somewhat different. And yeah, also a small remark. Often we get a question whether it's worth establishing a representative office. Nowadays, there are hardly any advantages. Of course, if the company only wants to explore the market, do some research, then of course it's worth establishing a rep office. But the problem is that actually there is a misperception among the foreign investors that it's easier to establish and liquidate a rep office, but it's not. So actually the process is very similar to that of the legal entity. And if you would like then to switch to the legal entity, it won't be possible. You will have to liquidate the rep office and then establish an LLC, for example. And then it will just be connected with additional time. and efforts and money. Here you see also a comparison between an LLC limited liability company and a joint stock company. I would say that a joint stock company is not popular with foreign investors. So usually they incorporate a limited liability company. As the name suggests, the liability is limited to contributions of the shareholders. It's the most popular form. There are almost no restrictions. So in Ukraine, the LLC can be established by either one shareholder or two, domestic or foreign. So there are only restrictions in some regulated spheres, but usually no restrictions. Shares, so they are indicated in percentages, so they're not numbered. They may be registered with the Central Securities Depository System, but it's usually not common. But for everyone who would like to search in the online register, will see the percentage of shares that the shareholder has in its possession. There is no minimum share capital required, so the company may be established only with €1 share capital, registered capital. But of course, with foreign companies, foreign subsidiaries, it's not common. Usually there is some reasonable sum there, because you should think in advance about financing the company. It can be established very quickly, within 1 to 3 days, as I have mentioned, and the main governing bodies are shareholders meeting, executive body, and supervisory board is also possible, but not common, depending, of course, on the size of the company. As for the joint stock companies, they're not popular. There are two types, public, not popular among the foreign investors, I mean, because the stock market in Ukraine is still not developed. There are two types, public and private. It's rather complex and expensive to incorporate a joint stock company. Because the process consists of various steps. It's establishing the company, also issuance of shares, registration of the issuance of share prospectus. The liability is also limited, and the shares are securities regulated by the National Securities and Stock Market Commission. Here we see the minimum share capital. It's approximately €34,600, but it depends on the amount of the minimum salary in Ukraine, so the sum is changing. You will need several weeks or even a month to establish a joint stock company. And the governance structure is actually similar to that in an LLC. But supervisory boards are more common, of course. So there is shareholders meeting, the main governance body. Then the board, maybe a two-tier board, one-tier board with the executive directors or supervisory directors, and can also be a supervisory board. So I will not go into detail. So further, I will speak mostly about limited liability companies in Ukraine because they are more popular. What is important to consider? Here, a couple of bullet points for every foreign investor and German investor to consider. It's not easy to open bank accounts in Ukraine, but as everywhere in the world related to the current trends and anti-money laundering procedures, it's the same in Ukraine. So previously, I just compare to the situation when I started my legal career, 2006. It was rather hard and difficult to establish a company in Ukraine. The process could take up to 1 month, but to open a bank account, that was just within 1 day. Now it's quite the opposite. You need 1 day to establish a company, but then perhaps up to 1 month to open a banking account, because the company will have to go through a complicated KYC procedure. But anyway, the process is not more complicated than in Germany. There is no FDI screening yet, so foreign direct investments, but there is a bill, a draft law, which is now being considered by the parliament. So the idea is to introduce this control mechanism. There will be a separate body established by the Ministry of Economy that will control foreign direct investments. But yeah, as I have mentioned, the bill is still in the parliament and being considered, but not adopted yet. There are several discussions, several alternative bills, and we will see. But just monitor this tendency. Yeah, the procedure will be applicable, for example, in such regulated spheres and important for the economy as infrastructure, energy, of course, also defense. So monitor the news. Of course, merger control is also one of the points to consider. Even foreign-to-foreign transactions might also be subject to merger control in Ukraine. The Anti-Monopoly Committee issues merger clearances. Could also be the case if you acquire the company or establish a joint venture with a Ukrainian partner or other foreign partner in Ukraine. UBO disclosure. So the disclosure of the ultimate beneficiary owner. This is something familiar also to German investors because a very similar procedure exists in Germany. We don't have a separate transparency register because this information is also visible in the general commercial register in Ukraine. You will have to disclose the whole chain of ownership till the natural persons and the end of the ownership chain. What interests the authorities is the natural person that possesses more than 25% of the ownership in the company. Usually we see some problems with German investors, German family companies, because this is family companies are popular in Germany. And sometimes, of course, it's not easy and some of the clients are reluctant to disclose this information of all natural persons, individuals, and at the end of the ownership chain. In Ukraine, they will have to provide this information, also rather detailed information, date of birth, nationality, address, and also the passport copies. But again, this is not unusual, something unusual. The same procedures and requirements exist in the European Union, in Germany as well. Just consider this. Generally, I would say there are fewer notarization requirements in Ukraine compared to Germany. You will have to notarize the articles of association, the resolutions of shareholders, which should be submitted for any registration to the commercial register. But for example, it's not required to notarize the share purchase agreement if you buy shares in a Ukrainian company, LLC, I mean. So this is quite a bit easier than in Germany. Of course, you may notarize the agreement if you wish to, but it's not required. So the notaries will not read aloud the whole text of the 100% long, 100 pages long share purchase agreement. This is a bit easier. Then the fiduciary duties of management. This is the concept that was also introduced to Ukrainian law recently. Duty of care, duty of loyalty, how to deal with the conflict of interests. We have all these rules in Ukraine now on the level of the joint stock company law, LLC law. So the rules are there. And you might also think about describing the main rules on the level of the company's documents. So in terms to better control the management. As for the management and the supervisory board in Ukraine, there are several options. Earlier it was they have had only dual status, so corporate function and employment function, they were all employed, the officials of the company. Now we have an option to conclude only civil law agreements, services agreements with the members of the management board and the supervisory board. But usually the head of the board and the members of the executive board have employment contracts. But nowadays, foreign investors have several options. You will also have to think if you appoint foreign directors about job permits and residence permits, if they're often in Ukraine. But just a bit of advertising, our employment webinar will have a webinar devoted to employment, also employment of foreign citizens, and you will receive more information about this. As for main corporate documents, in Ukraine, the main ones are articles of associations, the Bible of the company, also something usual and familiar to any German investor. If we're speaking about joint ventures in Ukraine, joint ventures with foreign or local partners, then of course the most important document is the shareholders agreement, where the parties regulate their rights, obligations, also the rules to sell the shares in future, exit. The founders or shareholders resolutions are also important. A lot of changes are based on the shareholders resolutions. Corporate governance regulations, for example, supervisory board bylaws. Of course, what we see, a lot of German investors prefer to have additional internal policies. They're not required by the law, but good to have. Various conflict of interest policies, executive body rules, and what you call in Germany Geschäftsordnung. It's also possible to implement them in Ukraine, but just be careful and adjust the clauses to be in full compliance with Ukrainian law, because there are some issues here. As for articles of association, in Ukraine, it's a quite straightforward document. There are only 3 or 4 requirements, what it should contain. Of course, the name of the company, the governance structure, whether you have a supervisory board, for example, the main competence, authorities of the shareholders meeting, executive body, supervisory board. Of course, the rules for transfer of shares in the company, preemptive rights, more important if you have several shareholders in the company, of course. Then whether these shares will be registered in the Central Securities Depository System. This is an option, but so far not very popular. And of course, a lot of non-obligatory clauses that you may also have. It's the registered address, corporate purpose, the scope of activities, registered capital contributions, the names of shareholders. But now it's not necessary to have them on the level of the Articles of Association. Of course, they are registered. All this information is registered in the Commercial Register of Ukraine, but you submit them in the registration forms, in the shareholders' resolutions. But now all procedures have been simplified in the law, in the new limited liability law, company law. If in this case, of course, if you need to change the address or the shareholders, you will not have to amend the Articles of Association. You will not have to notarize the document again. So the general recommendation is to have this document as simple as possible, just the main chapters required by the legislation. As for additional information, good to have, but just consider that you will have to amend the document if you make these changes, for example, change of address. As for joint ventures, in case you're going to establish the company with a partner or acquire a share and then further conduct activities with a partner in the Ukrainian LLC, of course, you will need a shareholders agreement and also reflect main rights, obligations, main rules in the shareholders agreement and also the Articles of Association. The rules, preemptive rights, consents, call option, put option, drag, tag along. So all these mechanisms actually common in the European Union. They're now also possible in Ukraine. Also a bit about the history. Previously, it was forbidden to have a separate shareholders agreement, even in the joint ventures in Ukraine. Nowadays, it's possible, and you can also subordinate this document to foreign law, by the way. Also indicate the arbitration clauses. So nowadays the law is very flexible, allowing more flexibility and more options to any foreign investor. Another mechanism is also revocable power of attorney. The investor, the shareholder, might also request to notarize the signature on various corporate resolution if it's required and desired. Then this rule will also be reflected in the register. Even it's not, for example, required to notarize all signatures, but the shareholder would like to safeguard its interests and protect its interests. Of course, this makes sense. Of course, it's also important to think about detailed governance structure, how you will manage the company with a partner, how you will describe the executive board and its functions. It's also more important if the director, one of the directors is the partner, is another shareholder, then you will, of course, have to think about all details on the level of main corporate documents. So this is generally main highlights about the rules that we have in Ukraine. My last slides are about the progress of Ukrainian laws. You could just see here how the laws progressed, the corporate laws within the last, 7, 8 years, I would say. In Ukraine, we have a squeeze-out law that allowed majority shareholders and joint stock companies to squeeze out other shareholders, paying them adequate compensation. We have a new limited liability company law since 2018. In 2019, we implemented the disclosure of the ownership structure and UBO disclosure, and then, of course, improved the framework of legal framework for the state-owned enterprises. So now they have received the general corporate governance rules popular in the European Union. Was also a requirement of the international financial organizations for Ukraine. So now we are gradually implementing all these procedures and provisions into the local legislation. And the last reform is the abolition of the commercial court. So this is the court. At the very beginning, I mentioned these various strange, weird forms, legal forms that still exist in Ukraine. Nowadays, they will change. All these companies will have to change their form and transform into a limited liability company, so that the legal framework and main corporate forms will also be aligned with the rules in the European Union. So this is my presentation, and of course, if you have any questions, you're welcome to ask them.
Thank you very much, Alesya. The first questions are coming in, which makes it easier for me. And the first question by Robert is, does an LLC with foreign capital have any advantages over one with Ukrainian capital? And the second one is, if a foreign national with permanent residence funds an LLC in Ukraine, is it treated as foreign or Ukrainian capital?
Well, I can't think about any advantages or disadvantages. Previously, when I started my legal career, it was also necessary to register foreign investments in Ukraine. It was an unnecessary additional procedure. Nowadays, there are no such rules. And again, previously it was even so kind of fashion to call the companies company with 100% foreign investment. Nowadays, it's not. Only just consider that in some regulated spheres, there may be restrictions for the number of shareholders and number of the foreign shareholding. As far as I remember, this is insurance, but also maybe some other narrow spheres. Just consider this.
So if that is, as you say, the second question is not relevant, the one about the permanent residence of the foreign national.
Foreign capital, yeah, foreign capital, because it's paid in by the foreign shareholder. Yeah, but yeah, this is maybe important only in terms of statistics in Ukraine. How many foreign companies we have with foreign shareholdings?
Okay. Thomas Hans, would a company be allowed to form a branch, what we call Niederlassung in Germany, which is more than a rep office, as it allows to execute normal commercial operations?
So there are two types of branches. Actually, the problem with the rep offices now is that they are mostly regulated by the tax legislation. We have several now new legislative norms and several laws, but they mostly concern the registration procedures. Then you will have to consult your tax advisor what is better to incorporate. So basically, we have two types. The rep office, but in terms of the taxation, the rep office without any commercial activity or marketing activities, and then with full commercial activities, they will be taxed in Ukraine as legal entities. And yeah, so here you will mostly have the difference in terms of taxation. You will have to consult the tax advisor in Ukraine. And you will, just join our next webinar. It will be in 2 months, I think, devoted to tax issues. I'm sure that the colleagues will describe the difference in more detail in terms of taxation.
Okay. There are people that are asking for your presentation. I'm sure we can share that after the webinar. And then Stefan has the question. You mentioned a rep office would have to follow tax code, etc., in case of commercial activities beyond
Permanent
market
establishment,
research in UA. Does that mean they could technically conduct such activities as rep offices too, but will in this case follow tax regulations?
Yeah, so the income will be taxed in Ukraine, but again, this is not my sphere. I'm not a tax advisor, but basically, yes. Yeah. So therefore, it doesn't make any difference actually whether you establish a rep office or an LLC in Ukraine. If you just think that it's easier to establish a rep office, it's not. And well, it's exactly the same procedure if you decide to liquidate it. It lasts the same amount of time as the liquidation of a limited liability company. Therefore, if there is a possibility that you will conduct commercial activities in Ukraine, of course, better go with the limited liability company, not a rep office.
Okay.
It's just a misperception, from foreign investors that it's easier to go with a rep office.
You have already answered the last question then. If I understand you correctly, so the rep office is harder to establish and to exit from than people think. The
It's the same, yeah.
The stock company is complicated too, which makes me think that the TOV, the LLC, is the best form that you can have. Does that also mean that most foreign companies actually do establish TOVs, limited liability companies?
Yes, exactly. But we still see some foreign shareholders in the joint stock companies, of course. And there are my 2 main reasons behind that. The first one is the local requirements. For example, for some forms, they may not exist as a limited liability company. It's banks, insurances. They must be must be in the form of the joint stock company. Also other forms, but no LLC, of course. And there is also another reason, historical reason again. I will go back to the 90s here. After the collapse of the Soviet Union, a lot of large plants and factories in Ukraine were privatized. And as a result, they were transformed into joint stock companies automatically, so only into this form. And they issued the shares, and the shares were distributed among their employees. So as a result, thousands of employees of formerly state-owned plants received the shares. Sometimes when the company didn't have any cash, it paid the salary with the shares. And as a result, now in some companies, we have thousands of shareholders, these minority shareholders. Most of them are not aware that, well, I don't know, 30 years ago, or 40, more than 30 years ago, they received these shares presented or as a gift or as the salary from the company distribution quota, and most of them have already died. So this was a problem. As a rule, these companies, for example, more than 90% are in possession of one shareholder, majority shareholder. And in my practice, we also had several such companies. When the German investor, for example, had more than 95% of shares, but all these 5% were distributed among thousands of minority shareholders. Most of them did not exist. It was a huge problem for Ukraine, and I have mentioned previously that we had a squeeze-out law in 2017, and I supported several German investors with the squeeze-out procedures. So the majority investor that possess more than 95% is allowed to squeeze out the minority shareholders. So we had a transitional period after 2017, and a lot of foreign companies, also German companies with the majority German investor, were able to squeeze out minority shareholders, pay, of course, the compensation for their shares, open escrow accounts in the banks. So we have now a very straightforward procedure for that. And at the end, they managed to accumulate 100% of shares. And after that, because all these companies, they're in their nature private companies, they're no joint stock companies. They're not never going to trade on the stock market. And therefore, they also changed the legal form into an LLC. So I personally supported several such projects with German investors, and this has simplified. But if, and again, back to your question, Rainer, if you still see some joint stock companies with foreign investors, this means either they may exist in this form only as banks, Raiffeisen Bank as an example, or this is a historical reason behind this.
And the follow-up, rep office, as you said, is complicated too. So what are the company's considerations when they actually do found a rep office? And is it suitable for testing, for example, military testing?
I would not say it's complicated. Actually, the procedure was simplified recently. It's the same as establishing a limited liability company. But yes, there are several restrictions. I haven't mentioned them. Depending on the license and the special permit, sometimes only a legal entity may have this permit. So depending on the sphere of the company or the rep office, you must take this into consideration. So it may be the case that in your particular situation with your activities, the rep office won't be able to apply for the state permits and licenses because it's not possible for a rep office.
Reiner, micro.
You're muted. Rainer, you're muted. We don't hear you.
Sorry. The requirements for the general director, Geschäftsführer, and the permanent in-house consultant, in-house accountant. It relates to basic running costs in case one wants to start an office in UA but not having substantial business from the start, or might actually never have. So you would want to keep running costs low. Which reminds me also of one fact. I think you cannot be, as a foreigner, be the first director of an LLC.
This has become easier now. You may also have a civil law services agreement with the head of the office, head of the company. But anyway, it depends whether you need to be permanently in Ukraine. If you plan to reside here permanently, you will need to apply for the residence permit. But the prerequisites or the grounds for the residence permit is the job permit. And in order to apply for the job permit, yes, you must have the employment relations and the employment contract with the company. So this is quite a complicated question, but nowadays it's possible to structure this also in such a way that, for example, if the manager is very rarely in Ukraine, he or she may just have the civil law agreement with the company and not be in the employment agreement, in the employment relations. But this is quite a rare case nowadays, but this is possible. You just need to, again, depends also whether you will need the legal ground to stay long in Ukraine. Yeah, then you will need employment relations, of course. If not, then several options are possible.
Yeah. Okay.
But yeah, as a general recommendation, of course, if you're going to establish a company in Ukraine, I would recommend to be there. And also, Reiner may confirm this to be involved into the local processes. Of course, it's recommended to be in the country. And if there are any issues with state authorities, by the way, yes, they will of course need to see the head of the company, the director, And I haven't mentioned this, but maybe now briefly, in Ukraine, we have two types of management boards. So at least either one director or the board. It's also the difference to German legislation. For example, in Germany, as far as I know, two directors on the board may be more or less the same, equally. But in Ukraine, if you have a board, there is one general director, the head of the board. He is the top of the company, and he is primarily responsible and liable to the state authorities. As for other board members, of course, you may also structure this in such a way that they are more or less equal. But mostly the state authorities will invite the head of the board. So this is the common strategy.
A question with regard to follow-up. Can we provide short answers to the questions together with the presentation?
Sorry, was that question for me?
Can we, as a follow-up to this webinar, we can share the presentation?
Yeah, of course.
And can we also put down short answers to the questions in the chat?
Yeah, sure. I think I see that somebody is asking for the name of the squeeze-out law and the number. Yes, I can send it because it wasn't only one law, changes in several laws.
Yeah. Okay. Any other questions?
Also, one more remark in terms of control. We also receive these questions from time to time. Actually, Ukrainian legislation offers a lot of options. You may, for example, we often get the question how we should better control the local management. How should we better construct this on the level of the local company? In Ukraine, there are several options, but they are also the same in Germany. You may, for example, on the level of the Articles of Association, describe that after some certain threshold, for example, if you need to enter an agreement for 50,000 euros, then the shareholders' resolutions will be required. The decision will be taken on the level of the shareholders. If it's, for example, between 10,000 or 50,000, then the decision will require the decision of the supervisory board or maybe two directors of the board. And everything what is below this limit is in the competence of the director or one of the directors. So the legislation is very flexible, but you need to fix this, describe all these rules somewhere. And then also mention in the commercial register that you have restrictions for the board members, because we have a separate line there, restrictions for management, representatives of the company. And of course, any restrictions that are indicated in the trade register, in the commercial register, will have importance for third parties. So they may rely on the information in the register. If it's only internal restrictions in the employment agreement, in the Geschäftsordnung, for example, then of course it's only your internal restrictions and it's not relevant for any third party. Just a recommendation to think about this.
I do not see further questions. And therefore I propose to have Adrian on.
I will stop share here. Yeah.
Yes, and then so that Adrian can explain what we can offer to companies. Adrian, the floor is yours.
Thank you, Reiner. Thank you, Alesya. Hello, everyone. Can you see my presentation?
Absolutely.
You can, that's good. Okay, then let me first introduce myself. So my name is Adrian Schairer. I'm a member of the executive board of AHK, head of services there, and also the CEO of DEinternational, which is the service company of AHK Ukraine. Regarding services, we provide different services for German companies for market entry. For example, delegation trips to Ukraine, which is one of our most popular services right now. But we are doing also business partner searches and we do legal consulting. And of course, we help also with establishment of a company in Ukraine, which, as Alesya lined out, is mostly the TOV, the limited liability company. Currently, we have 3 clients for whom we do the establishment of a company. And interestingly, they are mostly from the defense sector. So there's a strong interest also from German defense companies to establish legal entities in Ukraine now. And as you, Alesya, already mentioned, to have a local presence in Ukraine is a key factor for success. That's something we always tell German companies. If you want to be successful in Ukraine, you have to be in Ukraine. Of course, you can try to do it to control your business from Germany, but that's hard to do and hard to be successful because you're not that quick. And it does not necessarily have to be a legal entity. You can also have staff in Ukraine, but one instrument would be to have the legal entity in Ukraine, and then you can move quicker, the communication improves, and we would recommend you, if you plan to do business in Ukraine, to have a legal entity also in Ukraine. And with that, DEinternational, we can help you. We have a turnkey service for establishing an LLC. And I want now present to you how the process does look like and where we can support. So all starts with a personalized consultation with our German-speaking consultants to better understand the needs of the client and to clarify all potential questions. After that, we prepare all the necessary documents, of course, the articles of association, and after that, we can do the incorporation, the registration of the company. Normally, this process you can count with about 1 month to prepare the documents. Then they have to be sent to Ukraine. We get the power of attorneys, so you don't have to come to Ukraine to do the incorporation. We can do that for you. And then the registration is quite quick. That's 1 or 2 days. We can recommend you banks, also international banks who are active in Ukraine. And then we do the opening of the bank account. And what we also provide are services related to the LLC. For example, that can be then the bookkeeping, or we can help you with recruitment of staff. And also we do general consulting. And from the price, there will be no bad surprise. So we work with a fixed price quote. So you have the full budget control. And if you want to to get to know more about the service, you can go on our webpage. And there you can find the Recht, Steuern and Zoll section. And there, for example, we have the frequently asked questions. And of course, you can always contact me or my colleagues. I have their contact information here. That is Alexandra Yevstafieva and Yuri Kladun, who are always happy to help and to consult you. And that's it from my side. Thank you very much.
Thank you very much. We have a few more minutes left. And Alesya, I came to think of one more question actually that I also put in the chat about the public visibility of the ultimate beneficial owner, I think it's called. And I remember talking to the CEO of a German company who was very worried about especially the address of the ultimate beneficial owner. Is there any way to work around this, or is all of this publicly visible in the register?
Not all information is publicly visible. The rules that this is the name, the full name, the nationality, and the residence address. But you will also provide more information. The passport copy, by the way, it should be not older than 3 months, 90 days. And this is also the main concern of most of the clients. They would not like to provide their passport copy somewhere to the Ukrainian register. So the register will receive more information, but not all this information is visible. For example, the date of birth is not visible. What usually clients are doing, they indicate the address of the office. So, and in practice, we didn't have any problems with that. And this is also the general practice, also here in Germany, what I have noticed.
Is the address of the office. Okay. Of course, this is pretty relevant for a country that is in war, and in particular for defense companies.
Yeah, this is indeed one of the most important questions for many clients. Yeah, but again, it's not something new that Ukraine invented. These are general transparency rules everywhere in the European Union. Yeah.
But you might want to make an exception for Ukraine with regard to this. But okay, we do not have this.
So on one hand, the European Union is demanding more transparency from Ukraine. On the other hand, well, yes, we're implementing the transparency rules in Ukraine.
Yes.
This is what we are doing.
Okay. Are there any more questions by our audience?
Then, Reiner, how we'll proceed with the questions? Those that we did not answer, for example, the number of the law and all this, I can maybe share the answers with you, and then we can.
We usually do a follow-up email to such webinars, and we can provide answers there. We can post a link to the presentation, which, I don't know, can be uploaded to your website, Hogan Lovells, or to our website, or both.
To your website, yeah.
Let's upload it to our website, and then people can access this, and then we provide the answers and maybe your address and email Alesya if it is not included in the presentation.
If it's a short question, of course I will answer it. It won't take much time. Thank you.
Well, it seems there are no more questions here from the audience. Do we already have a date for the next Legal Basics webinar? I'm not sure if my team, if we have it.
Yes, I don't remember it now. It's the end of April. You will receive, so I think our audience will receive the invitation.
Yeah. If we have the date, we will also share it in the follow-up communication with you.
Yeah, it will be employment issues, so the basics of labor law in Ukraine. And then the next one, tax, and then we will keep you busy till the end of the year. We will have a separate topic at the end of every month, and till the end of the year, exactly.
Thank you for taking care of this, of the organization, and thank you for today, Alesya, and thank you to our audience for tuning in.
Thank you.
Have a great day. Thank you.
Thank you. Bye-bye.
Bye.